Hey there, I'm Louisiana estate planning attorney Paul Rabelais, and in this video I'm going to go over how a Louisiana succession works when the person who passed away didn't have a will. All right, when somebody dies without a will, they're deemed to have died intestate. If they had a will, they're deemed to have died testate with a last will and testament. So this is the scenario where somebody dies, they owned some assets, they didn't have a will. What in the world happens? All right, so practically what typically happens is those surviving family members start a conversation, maybe a few days or a week or two after the person passed away, and they talk to a lawyer because they're going to need a lawyer to get through the process, and they'll explain that there was no will. And so maybe the first thing that will happen is they'll take just a quick look at what are the assets that the person owned when that person died. Did they own a home? Did they own any other real estate? Did they have any bank accounts? Did they have any investments? Did they own a business? Did they own vehicles? So a quick overview of, to the best of the surviving family member's knowledge, what are the assets? And then we have to determine who the heirs are. Can't make up who the heirs are. It's fixed. The person died without a will. And so our Louisiana law dictates who gets their stuff. And who gets their stuff depends on the circumstances of the deceased person. Were they married? Did they have kids? So let's go through a couple of those scenarios. First, let's talk about the deceased person is married and they had children. So, and then we have to look at whether that person owned separate property or whether they owned community property with their spouse. So the person who died is married and they had children. So as we go through that analysis of who inherits, let's talk about first the deceased person's separate property. If they had any separate property, maybe they didn't have any. Separate property is things that they acquired before they were married, or something that was given to them or was an inheritance that they received. Well, if they had any separate property and they had kids, their separate property will go straight to their children. Their surviving spouse will not have any interest in their separate property. If that married person had community property with their spouse, and typically that's assets that they've acquired together, salaries and wages that either one of them earned, things that they acquired during the marriage, that's community property. And what happens to the married person who died without a will is, let's take that community property, let's call it $500,000 of community property. The surviving spouse will continue to own their half of the community property, and the surviving spouse will inherit a unique Louisiana term called usufruct. The surviving spouse will inherit the usufruct of the deceased spouse's one half of the community property, and that surviving spouse's usufruct, or right to use the property, lasts until that surviving spouse dies or remarries, whichever comes first. And then those assets that the surviving spouse has usufruct of, when that usufruct terminates, go to the naked owners, and that's the deceased person's children. So separate property, straight to the children. Deceased spouse's half of the community property, surviving spouse inherits usufruct until death or remarriage. Children are the naked owners. Okay, so that's the heirs. Then the next thing we have to do is we have to decide whether there's going to be an administration of the estate. If things are very, very simple, and simple is a relative term, there often will not be an administration. Typically there is, though, in circumstances like this. Maybe accounts are frozen, there's some debts that need to be paid. You need to get an administrator appointed so that administrator can gain access to accounts in the name of the deceased and pay bills and debts and other estate expenses. So when a person has a will, which in this case they didn't, but if they had a will, that person is usually called the executor. And since they didn't have a will, one of the family members probably is going to step up and kind of volunteer to be the administrator. Maybe the other heirs will all agree. And so we'll file petitions at the courthouse asking a judge to appoint this person, maybe a surviving spouse, maybe one of the adult children, as the administrator of the succession. And assuming all of the heirs agree, we'll want that person to be what's called an independent administrator so that they can take certain actions, without having to go ask permission from a judge each time. Once they're appointed the administrator, then that administrator has court paperwork, which enables them to go to a bank or a financial institution and establish an estate account. And then that administrator will pool all of the estate funds from perhaps the different banks, and they'll pool all of those funds, and perhaps even from the sale of estate assets. All those funds get pooled into an estate account. And then there's what's called a detailed descriptive list of assets and liabilities prepared. A judge isn't going to authorize that any assets be transferred to the heirs until that detailed descriptive list, that detailed list of assets and debts, is all filed as part of the succession record. The administrator is going to make sure any kind of debts were paid, funeral expenses, credit card debts, any other debts that the estate may have had, medical expenses. And then towards the end here, there's another petition that all of the heirs must sign, or all of the heirs will agree to it, and where all of the heirs are asking a judge to sign an order ordering that any remaining assets be transferred, separate property to the kids, community property, usufruct to spouse, naked ownership to kids. And then we get that judgment signed by a judge, and then we get that judgment to various third parties so that they're ordered to transfer assets to the appropriate people, whether that's the Department of Motor Vehicles, whether that's banks. We'll get that judgment recorded in the real estate records of the parish where the deceased person owned real estate, and that's what reflects the transfer of ownership out of the name of the deceased person of real estate. So this ought to give you an idea of what's involved in a Louisiana succession. You got to work with somebody who really understands what they're doing, because there's so many different parts, and oftentimes there's several personalities that are involved in the completion of a succession from start to finish. I'm Paul Rabelais. Make sure you like, subscribe, comment, all that good stuff. We'll see you next time.